Hi everyone, my name is Ellie Rogers and I'm a Senior Associate at Constantine Law. I'd like to introduce my colleague, partner Catherine Wilson, and today we're going to talk to you about sort of a new year reset, how to plan redundancies, look at settlement agreements, and also bear in mind what is going to happen in the future in terms of the Employment Rights Act 2025. So over to you, Catherine. So we were talking earlier, and one of the things that comes up time and time again is what is a redundancy? So what are your top tips here?
Well, I think the first thing to be aware of is that redundancy is not just a sort of artificial phrase. It does actually have a specific legal reason, and it does matter that we call reasons for dismissal by their correct terminology. So there are two things to think about when you're looking at a redundancy. The first is the fact that it's either a disappearing job or a disappearing workplace. Another key point to make is that it doesn't really matter if elements of the job remain. You wouldn't have employed them and paid them if everything was going to go. So it's not everything having to go. Obviously that's the case if you're looking at a disappearing site, but most of the examples are disappearing job or changes in the job.
That's a really good point, and I think sometimes that gets missed with our clients, doesn't it? I mean, it's a really good place to start. So looking at consultation, what's your view on consultation? What do we need to look at? What are the key issues here?
Well, I'm sure you'll agree, Ellie, but the key thing is to make sure of your numbers. So we need to know roughly, not exactly, but roughly how many people are likely to be redundant. And that matters because the consultation on a collective basis depends upon how many people are involved. And the key triggers are 20 or indeed 99. If it's less than 20, then there isn't a need for a collective consultation, though there is a need for an individual consultation. However, if in doubt, always err on the side of caution. So my view would be if you're around the 19 or 18 mark, always assume that it might go up to 20 or more, particularly because things that you might not be aware of could also be covered, but also things like voluntary redundancies and redundancies done under a settlement agreement, more about which later, could also count towards the numbers. So think wide, don't get too hung up on the fact that you must bring it in under the 20.
Absolutely, and actually I've had a couple of clients recently where they've actually had to make far more redundancies than they'd anticipated at the outset. So I totally agree, like err on the side of caution and collectively consult if you need to. What happens about disclosure and privilege? This is something that I think clients sometimes get a bit confused about. Can you just explain what those 2 points mean?
Well, the first thing to say is that people assume that everything you discuss, which is of a confidential nature within your organisation, is not discoverable. So you do see lists of people that would ideally be exiting the business, for example, or indeed very detailed plans. The problem with that is that consultation does what it says on the tin, and it's got to be capable of change. So if your plans look too entrenched, then the argument is the consultation is not a fair process. At the same time, consultation with us is usually covered by advice privilege, so can't be discoverable and disclosed, for example, in any tribunal proceedings, which is a massive advantage. Internal discussions, particularly those with your finance and HR team, in contrast, however, can be discovered and indeed are frequently asked for if things go really badly wrong and we end up in a tribunal.
Yes, I also act for individuals, and so that would be the first thing I would ask for if it was missing from my disclosure list. So that's a really good point. So we're looking at numbers. We talked about this just now, but how do we count the number of employees that we're going to propose as redundant? How do we count those? Can you summarise that for us, Catherine, please?
Well, I think the key things to bear in mind there is it's the number of employees currently at a particular establishment. So you could have lots of small redundancies over several establishments or separate business units, and they may not add up to 20 at one. And the argument is if there's not 20 at one, then you don't have to collectively consult. As Ellie said, that is actually going to change because the Employment Rights Bill, when it comes into effect, gets rid of this whole idea of establishment. And in a way that will make it easier, I think, for employers. because it will be then about the business rather than having to remember which bit is or isn't included. Because don't forget, when we're looking, let's say, at our 20 days or 20 people, we're looking at those 20 over a 90-day period, which is quite a long period of time, and lots of things may or may not happen in that time.
Absolutely, and we have to look forward and back, don't we, from
exactly.
from the dismissal. So that 90 days backwards, 90 days forward, that's a really long period of time. So looking at establishment, what's the current test there?
Well, the current test goes back to some of you who are a bit older on this podcast may remember a lovely shop called Wolves, which did an excellent pick and mix. But in fact, one of the sad things was we obviously got fed up of pick and mix, and so a lot of those shops closed. But there was a massive issue about whether or not they should be 20, because most Woolworths stores were within that 15 to 25 people bracket. And if there were 15 people who were working there full or part-time or engaged, and it had a high level of autonomy, what I mean by that is separate finance function credit, then the argument was that's an establishment and we should count our 20 by reference to that particular establishment. That control test, though, continues. But as I say, I think that's likely to change because we will move into a one business model. I think the view is there isn't enough consultation. Those of you who've been through one of these exercises may think there was plenty of consultation. However, that's not what the courts think. And the view is actually we probably need to do more, not less. Don't forget as well, when we're looking at our 30 days, so our 20 to 99 and our 45 days, that actually those are minimum periods. And I can think, as I'm sure Ellie can, of lots of redundancy exercises where in fact consultation took place over a much longer period. And don't forget, the start point is that consultation must be completed before the first of those redundancies takes effect.
Absolutely. So we've been talking about collective consultation. I think it's always important to sort of understand what could potentially happen if you get it wrong. So under collective consultation, there's a duty to inform and consult. And the protective award is pretty huge, isn't it, Catherine?
Yeah, I mean, the protective award more currently is 90 days actual pay. So none of the caps that we see, for example, in relation to statutory redundancy payments would apply in this instance. I think it's also really important to think about who are we collectively consulting with. And those of you who've got a union, then it's obviously obvious who you're consulting with. For clients who don't have unions recognised for those purposes, they can set up an individual consultation body with individual employee reps who are elected, or they can utilise one of their existing consultation models. The latter, there's obviously got some benefits to it, but it does take quite a lot more foresight because it needs to be well organised and they need to be structured in the right sort of way. But again, if we're looking at the Employment Rights Bill, I think we will see more of those sort of staff council arrangements coming into place. And certainly when we're looking at collective consultation, it can be highly effective. Though don't forget, we've always got to go for odd numbers. People do drop out. We want to make sure at the end that we have enough people to speak to and that those people do not feel lonely and isolated, because it can be quite tough being a rep, particularly if you haven't got a union backing you.
Absolutely. I mean, it's a big job and it requires proper training, doesn't it? You can't just, these employee representatives are representing their peers and quite frankly, they need proper training in order to do a good job. I suppose also under the new government, we think that, or at least the new government hope that more workplaces will become unionised. So previously, for example, Amazon, there was a ballot to see if they could become unionised. That failed, whereas under the new legislation, it would be more likely that would be successful. Don't you think, Catherine?
I think so, because I think the thresholds are going to be an awful lot less. And also the unions are going to have an awful lot more access to workplaces. And it's going to be a requirement that individual employees are notified when they join of their right to join a union. What we don't know is whether they're going to be notified of their right not to join a union. But certainly I think there's going to be a much higher profile, and you would expect that to filter through into more members.
So that's really an action point for larger workplaces. If you've where you have say 100 or more employees, really something to think about is whether you have a body of, or an established body of representatives in place, and perhaps that would then prevent your work or your your workers from feeling that they should be unionised.
Yes, I mean, I would agree with that. I mean, I think we will see a higher focus on unions. But equally, I think the whole involvement of the staff and consultation is such a big issue in itself. I think it's also going to be more important if we go away from this establishment mode, because some of those discussions about selection and alternative employment are a lot easier to deal with if you're looking at one particular establishment. But if, let's say, I'm looking at an organisation in Sheffield and Maidstone, for example, then clearly it's quite difficult in terms of, particularly when we're looking at working from home and things, how do I look at what other alternative employment is available? Because even if my job goes, I'm not myself redundant unless I can't find an alternative role for me.
Absolutely. So it will be interesting times ahead, I'm sure of that. So we've sort of galloped through consultation. Just a quick word that, of course, we also need to be individually consulting with our teams. But before we get there, well, let's think about selection. So, I mean, there are a number of common pitfalls that we come across. What's your view on this, Catherine?
I think there's an innate conflict, if you like, because most of my employer clients always want it to be as small a group as possible. They feel that's less disruptive and that's the best way of keeping the people who are going to be really good for the business going forward. It would be fair to say that tribunals are a bit more sceptical of that and basically want larger groups of people, and they want employers to think more laterally about whether somebody could or couldn't do a particular role. I think the key starting point, and I don't know what you think, Ellie, is to make sure that we end up with the people that we need to give the business the best prospects of success in the future. So selection is key in that. And we do struggle, I think, to find what I will call more objective criteria. We tend to focus an awful lot on the subjective, and that the objective criteria, things like disciplinary record, for example, don't give us enough of a differentiator. Whereas we would like to look at performance, but we're not totally confident that our actual performance reviews and appraisals would actually stand up to too much scrutiny. So there is a bit of a conflict there, and trying to work out a process of selection, for example, through interview or presentation, where you can look and get a bit more objective data, I think is a really important describer and very important in terms of getting the right people, because that's the whole point, and making sure that your process stands up to challenge, because these are not apocryphal tales. They are challenged, and people do look at selection. And in fact, most clients fail on consultation, but the biggest failure area is selection, and the selection point not being fair.
And even law firms get it wrong. It's one of those areas that actually, there are many things that we need to think about, including sort of automatically unfair reasons. So using discriminatory criteria. Sometimes I imagine employers feel that they can't do wrong for doing right. So are there any things that you think we should be looking out for there?
Well, I think we definitely, it's a well-worn track that the attempt to, for example, if we look at one particular notorious employment law case involving a firm that I may or may not have actually worked for in the past, one of the issues there was to actually enable them to ensure that they didn't discriminate against the fee earner who was on maternity leave. They actually discriminated against the fee earner who wasn't on maternity leave. They didn't give enough of a weighting in the tribunal's view, for example, to the debt management and how they dealt with their clients. So you can be damned if you do and damned if you don't. We know there are lots of specific prohibited reasons. So, for example, clearly we have to exclude anything to do with maternity and pregnancy. Ill health is also problematic. What do we do with our disabled employee who may have slightly poorer sickness record? What do we do about somebody who's off work because they've had a health and safety incident at work and that's caused it? So there are quite a lot of difficult areas. Obviously, again, somebody who's perceived as a troublemaker, grievance, whistleblower, those types of things, that does not put you at the front of the queue for redundancy selection. Other final point I would say in my own experience is that where individuals have brought discrimination claims against the employer but continue in employment, which does again happen quite frequently, we must take doubly sure that they are not somehow seen as the ideal candidate for redundancy. I can appreciate that for some clients they have proved to be very difficult to manage, but that doesn't mean that you're necessarily redundant. So I think a lot of care is required, and a double checking, and particularly where there have been issues, shall we say, harassment, bullying, arguments, we need to make sure there's some sort of external third party, whatever, review of what we've actually done.
Absolutely, and that's something that we can help with. So little advert for ourselves there, but it is, something that, absolutely, to have a third party look at it and look at the objectiveness of it and any unforeseen consequences is always a good idea. Now onto one of your favourite topics, Catherine, your little grenades, as you like to refer to them.
Yes, I do like to refer to them as the grade, and these are the dreaded settlement agreements. Now, settlement agreements have been around a long time. We started with them in 1993, so you would think by 2025 we'd have got them pretty well sorted. I call them a grenade because they are superficially very simple. They're like a little plastic thing, and you would think, oh, dead easy to use. Unfortunately, they have a lot of traps for the unwary. And I would say that because we don't realise quite how important they are as documents and all these tweaks, it's quite easy for a client to use the wrong agreement. They do get out of date. They do need to be checked. Please do check with us before you send out our agreement with our details to different solicitors on the other side. That happens a lot. They need a regular review to make sure that they are compliant. For example, in terms of the tax treatment of the notice pay, we've got a whole focus now on non-disclosure agreements. You can't just use the same old document and hope it will work. Very tricky as well. I mean, I think the other thing that I think is also worth thinking about, Ellie, and perhaps you can talk about this, is the agreement is fine. However, we do need to be careful about how we introduce that agreement. And are we doing it under the guise of a protected conversation, and or is it without prejudice? Because I think, as we would say, Ellie, clearly some of these documents do not work in every situation. Do you agree?
Oh, absolutely. So without prejudice, so that means in effect that you're sending correspondence to the other side or corresponding with the other side without prejudice to your position. So ultimately it shouldn't be shown to a court or a tribunal. However, for the rule to apply, there has to be an existing dispute. So some kind of disagreement between the parties. And the correspondence or the communication can only apply to where there's a genuine attempt at trying to resolve the dispute through settlement. We often find that people will try and use the without prejudice rule or protected conversations, as I'll come on to in a moment. They try and use them as a sort of a way to have a secret squirrel conversation, and I'm afraid it doesn't work. It's so we have to have an existing dispute, and it has to be a genuine attempt to resolve the dispute through settlement. So this without prejudice rule does apply to all types of employment tribunal claims. But there are some exceptional circumstances where the communications wouldn't be deemed without prejudice. So, for example, if you're trying to perjure yourself or the other, if there's some kind of fraud or blackmail, then you can't rely on the without prejudice rule. So, Catherine, I think protected conversations came in was it 2010? Sometime around that. Yeah, absolutely. So these are used. There's often a grey area between where if there is no dispute, but people are thinking about moving an employee on. So this was introduced in the Employment Rights Act, and it can be used if there isn't an existing dispute. But it has to be used in very limited circumstances. So it can be only where there is where there's a discussion about terminating the employment on agreed terms. So have you ever had it, Catherine, that the employee has raised a protected conversation?
Yeah, several times actually, usually after a disciplinary hearing that hasn't gone terribly well. So that seems like a good, better attractive option than actually just being dismissed. I think as well, though, the biggest areas are where the individual employees raise some sort of whistleblowing thing and or there's a discrimination element, usually disability discrimination in the context of a sickness absence dismissal. Those are not covered by protected conversations. And I think clients have found it very tricky because if the negotiations don't result in a settlement agreement, then at that point there is the risk of a claim, and a lot of the concessions and discussions, which hitherto might have been thought to be, confidential, then can become part of the dispute. And that's probably not what was intended, but that's because of the incorrect labelling of the discussions themselves. So that does happen quite a bit. I think the other thing that clients get quite confused about is, how long do I have to give somebody when I've started my protected conversation to consider my options? Key points there are, the individual doesn't have to agree to have a protected conversation, and just because they agree to the conversation doesn't mean they have to agree to a settlement. And we can help you with that in terms of giving you a little script to make sure that everybody is clear about what their options are. The other thing as well is, you see a lot of reference, don't you, Ellie, to this 10 days. And the ACAS guidance, which is trying to ensure fair play, and in particular that employees are not bullied. And so when the legislation came in, there was a code, and the code said 10 days. Generally speaking, 10 days is probably slightly on the longer side. However, there are instances where in fact 10 days isn't enough. Final point from me as well about these is, don't forget as well that if we're dealing with somebody with a disability, I'm thinking particular mental health related issues, they probably would need to have a longer time to get more in-depth advice as to quite what the consequences of the actual agreement are. Have you got any other tips, Sally, on that?
Well, I often tend to hedge my bets between the protected conversation and without prejudice. So just in case if we're going with a protected conversation and there's no existing dispute, just in case, hopefully we could rely on the without prejudice rule. I also think, the improper behaviour point, if it's found that you've been pressurising the individual too much, or you're very you're in effect threatening them through the protected conversation route, then obviously this will not apply. So it's often helpful to go to a meeting, so have somebody who leads the conversation, and then have another member of staff from the organisation who takes a really detailed note and is very clear on the sort of the tone of the conversation, so that there's no, or you can reduce any risk that the individual will say that they've been pressurised unduly. I think they are a good tool, but as you say, they do need to be up to date. I had a settlement agreement fairly recently that referred to the Inland Revenue. So the Inland Revenue went out in 2005, I believe. And since that point, there have been so many changes in legislation. So often you're paying a load of money to protect your business, and actually the settlement agreement doesn't do that. So as Catherine says, it is worth coming to us, and we can help you navigate the conversation between whether you needs to be without prejudice or if it's a protected conversation, and then also make sure that settlement agreement really is fit for purpose. But it's a useful tool, but it has to be used properly.
Absolutely. So
I think we've just got time just to quickly talk about fire and rehire. So this really came into the fore with P&O ferries, didn't it, Catherine?
It did, because it appeared that P&O were prepared to completely ignore all of the legislation, and to some extent they did. What effectively meant was they didn't consult. They informed their employees that as of immediate effect they would be taking a massive hike or reduction in pay, and if they didn't like it they could leave or they could stay on reduced terms. This caused a huge amount of consternation, because the view was that it rode a complete coach and horses through all of the accepted practices and indeed legal requirements. Also noteworthy in this instance to fact that in fact P&O paid out the maximum level of compensation. So we've already talked about the 90 days. Everybody got 90 days. Everybody got their full statutory redundancy. Everybody got their full notice pay. Argument being, if you pay them everything then clearly there's no need to consult. Now, that was expensive, but they thought it was still worth it. Again, if we look at the Employment Rights Bill, that will change, and they're consulting about whether or not 90 days is enough. And in fact, should it be unlimited? Because then you wouldn't be able to simply pay your way out of the consultation process. I think it's also relevant in context to say that actually, as in July, there was a new code of practice that came into force in relation to how would you affect a fire and rehire process. And again, in January, there's a further code. It's all pretty straightforward stuff, but the key points are that you need to have a reasonable reason and you need to have a fair process. And insofar as there are collective consultation obligations, you need to comply with those, because if you don't collectively consult, you can't really show that you've done a fair process, and the individuals are entitled then to pursue their own individual claims. And as we said, 90 days may not have been a lot for P&O, but for most clients, 90 days actual money on top would be perceived as a significant amount. Anything else you would want to add, Ellie?
Well, yes. So from the 20th of January, tribunals and courts are now required to take into account the code of practice. So if you are dismissing and re-engaging, even if it's just one member of staff, you have to take the code into account. And if you fail to do so, the tribunal can award up to 25% extra compensation if it was unreasonable for you to ignore it. So that's just like the grievance and disciplinary procedures. Sometimes you'll get a bill for not quite going through the right process, but this really is a kicker of an extra 25% on top. So, and as Catherine, as you just said, this is probably going to get a lot harder. The Employment Rights Bill, or as part of the changes that the Labour government is bringing into force, the code of practice will be made even stronger, and so dismissal and re-engagement would only be allowed where restructuring is there's basically no other alternative. So it will only be allowed in cases where the company is probably about to go into administration. We're going to have to look at the detail of it, aren't we, Catherine? I think just to sort of work out where we stand with that. But certainly it looks like now is probably a reasonable time to think about reviewing employment contracts. And if there are changes that you need to make, to start looking at that now. But bearing in mind the code of practice, we need to take that into account.
Absolutely.
Do you agree?
Yes.
Good. Excellent. I'm glad we're on the same page. Well, thank you very much, Catherine. Unless you have anything further to add, I think that's all for us today.
No, thank you. We hope you found it useful. And, these are challenging times, but I think with the right advice, you can get through them.
Absolutely. And we're here to help you plan.
We are.